Hi, everyone. Thank you all for joining us for today's presentation. My name is Marissa with Legal Aid's Helpline. Today, we have Jennifer Stewart presenting for us. If you are unfamiliar with the format of this event, first, Jennifer is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point in the presentation you have questions, put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and we are not representing you at this time. Jennifer will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. We will not take any more questions after 4:20, and we'll have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Jennifer to get us started.
Good afternoon. What I'm going to talk about today is wills and advance directives. These are commonly referred to as end-of-life documents. Sorry, I got a little bit out of order. Just one moment. Okay, so I will be doing a brief introduction on what legal aid is, in case you're not familiar with our organization and what types of services we provide. I'll talk about 4 common end-of-life planning documents, and before we conclude, I'll go over what the requirements are to properly sign those documents and make them legally valid. In case you're wondering who I am, just a little bit about me before we start. I attended the University of North Carolina School of Law at Chapel Hill. I have worked for Legal Aid for over 20 years, and I'm a supervising attorney with the Senior Law Project. That's a statewide project of legal aid that is geared towards serving clients age 60 and older. I'm based in Raleigh, but I travel to a lot of counties around Eastern North Carolina to meet with clients there as well. Couple caveats before I really get into the substance. This is just going to be a quick overview. It's going to be very broad. I'm not going to go into a lot of depth. And along with that, I am going to be giving general information. And as you heard already, I am an attorney, but I am not your attorney, so I can't get into specific legal advice about your situation. I will be happy to answer as many general questions as I can. I'm only going to be talking about North Carolina law today. This comes as a surprise to people sometimes, but our state laws do vary on this topic. So if you live in another state or even another country, the things I'm talking about may not all apply to you. I am only going to be talking about these documents as covered by North Carolina law. So in case you're not familiar with legal aid, we are a statewide nonprofit law firm. People often mistakenly think that we are a government agency. We are not. We are a nonprofit, but we're also a law firm, and we provide free legal services in civil matters. We don't do any criminal cases, but we cover a range of civil matters for low-income people with a mission of ensuring equal access to justice and removing legal barriers to economic opportunity. Some examples of the types of cases we handle are helping people get domestic violence protective orders when there are survivors of family violence. We help tenants fight evictions. We help appeal adverse decisions when people are denied public benefits that they're entitled to, such as food stamps or Medicaid. We assist homeowners who are facing foreclosure, and we help stop illegal debt collection. We also help protect essential property from creditors. So those are some examples of things that we regularly do in all of our offices across the state. For end-of-life planning documents that we also prepare are the will, which is often called a last will and testament, the financial power of attorney, which people sometimes refer to as a durable power of attorney. We've got two healthcare directives, a healthcare power of attorney and a living will. Now, these names often get mixed up and can get confusing. The living will, for example, has nothing to do with the first item, the last will and testament. The living will is a healthcare directive, and it has nothing to do with what happens with your property when you pass away. So should you have these end-of-life planning documents, or why should you have them? They can be very helpful in case you become sick or incapacitated and you're unable to do things for yourself. It's a good precaution to take to have these in place while you're able to make decisions about what you would want to happen if a time comes when you can't make decisions. People often say to me that they'll just wait and get this done when they need the documents because they don't need them right now. But that is usually a mistake, because if you wait until you need the documents, that's when it's usually too late. You need to have the capacity to make decisions about the documents and to sign them in order to get them into place. So these are good to have in place while you're able to make decisions about what you want. They can help make sure that things happen the way you want them to, that the people you trust and that you would choose are the people that are in charge of things. And as far as your property passing after your death, if you don't want that property to go to your biological relatives, that is a reason in itself to have a will. And I will get more into that when I talk about that document. So what is a will? I think most people have a basic understanding of what this is, but it does get confused with the other documents that I mentioned. A will is only about your property passing after your death. It's about who you want to get your stuff after you pass away. So it's a legal document that sets that out. And you can also in your will say who is going to manage that property until it's passed on to your heirs. That person is called an executor when you name them in your will. And it is your choice who that person is. It's going to be in charge of distributing everything, making sure that debts get paid off and that your affairs get handled properly. Now, when does a will take effect? It has no effect and no meaning at all legally until the day that you pass away. And this comes as a surprise sometimes to people. It's not a contract. It doesn't guarantee your beneficiaries that they're going to get anything, because you can change your will. You can change it as many times as you want to, as long as you're mentally competent to do that. You can also give your property away during your lifetime. So if I write a will today, giving all of my property to one person, and then tomorrow I write a will giving all of that property to a different person, that first person doesn't get anything because I've changed my mind and I've changed my will. I could also give them all my property away, and then it doesn't matter what I've said in a will. Nobody's going to get anything that I don't have. So when you pass away and you have a will, the property at issue is the property that you have on the day of your death, not what you had at the time you signed the will, not what you had 20 years ago or a month ago. We're going to look at the property that you have on the day of your death, the property that you actually owned at the end of your life. And that's what's at stake. So a common misconception is that if you die without a will, your property goes to the state. And that simply is not true. Your assets, if you don't have a will, are going to pass through what we call the laws of intestacy. This is basically a statute under state law that lays out which next of kin gets your property if you don't have a will. It starts with your husband and children if you are married and have children, but then it goes down to siblings, parents, nieces and nephews, and it lays out a very specific order and rules for who gets what. And so it's basically going to be your closest family members. Again, like I said before, if you don't want your closest family members to get your property, if you want to leave things to friends or maybe a distant cousin, or someone, any different arrangement than what the intestacy statute says, then that is a reason in itself to have a will so that your property goes to who you want it to go to. Now, I think one reason that some people sometimes think that the property goes to the state is that if you are in nursing care, if you're in a nursing home and getting long-term care, and you owe money to Medicaid, it is true that the Medicaid office can file a claim against your estate like any creditor can and claim what they are owed after your death. So that is one instance in which some of your assets may end up going to the state, but it's not automatic. It's never automatic. They have to file a claim like any creditor can against your estate. This has nothing to do with whether or not you have a will. This can happen either way, with or without a will. If you owe a debt at the time of your death, that debt does have to be paid, as long as the creditor, the person or company that you owe the debt to, follows the rules for collecting that debt from your estate, then it does have to be paid. Some people do try to plan so that they won't have to pay Medicaid out of their estate, and there are ways to try to prevent that from happening. That type of planning is very complex. So if you're interested in that and have significant assets, you may want to talk to an attorney who specializes in Medicaid estate planning, because that does get very complex. So the next document I'm going to talk about is a financial power of attorney. This is also often called a durable power of attorney. When people just use the term power of attorney, referring to a person, they often mean your agent. So the person that you appoint in this document to handle your affairs is your agent. This is someone that you choose, who you trust to handle your finances if you're unable to. Some examples of what you can authorize somebody to do under your financial power of attorney are access your bank accounts and write checks from those accounts, transfer money from one account to another, call your car insurance company to cancel your car insurance, call the property manager of your apartment complex and find out if your rent is up to or paid up to date. So basically, any financial matters and personal affairs that need to be managed, you're giving someone authority to do those things. And it is up to you how much of this authority you grant. So you can grant as much or as little authority as you'd like, and that is up to you. As far as when a power of attorney takes effect, it can be effective right away when you sign your power of attorney, or it can only take effect upon some future event, such as if you become incapacitated, it can no longer handle your financial affairs yourself. If it goes into effect right away, that doesn't mean that you have to stop doing things yourself. You can still handle your own affairs as long as you're able to. It just means that your agent doesn't have to get anything additional in place, such as a letter from your doctor saying that you're incapacitated. If you choose to make it effective when you become incapacitated, then you would also say who decides that you're incapacitated. For example, a doctor. So you would make it clear who can make that determination that you're incapacitated and it's time to start using the document. Now, even though your agent is given access to your finances, they must use your money in a way that benefits you and is in your best interest. Your agent may have the authority to write checks from your account, for example, but they should not be writing a check to pay their own cell phone bill. So once they start using the document, they have what is called a fiduciary duty, a legal responsibility to do what is in your best interest. And even though they have that legal responsibility and should only be using the document for what is in your best interest, practically speaking, this document does give broad authority, and it makes it creates the potential for financial abuse and exploitation. So it does give someone access to your money and your accounts. Now, your agents are not supposed to use this to benefit themselves. That doesn't mean it doesn't happen. We commonly hear about it happening, unfortunately. So I think this document is a great thing to have in place, but it's also equally important that you pick somebody very carefully who you trust and who is not likely to take advantage of the situation. It also helps to pick somebody who is organized and good with details, someone who is in a good position to manage things and be proactive and figure out what needs to be done for you. People often mix up the concept of power of attorney with guardianship. Guardianship is a very different construct. It's not the same thing as power of attorney. A power of attorney by itself does not take away any of your own decision-making power. You have the right to keep doing things on your own as long as you're able to with a power of attorney. It just gives your agent authority at the same time to help you with whatever you need help with. But your agent does not get to just take over your finances or your life with a power of attorney. A guardianship is much more restrictive, and it is something that you can only get through a court order. And in North Carolina, to get such a court order, to have a guardian appointed, you would have to be declared legally incompetent, which of course is a very big deal. And so that's very different than just having a power of attorney. People often think of a power of attorney as a way to try to prevent guardianship, to prevent the need for it. People often ask, how do I get power of attorney over my mother? Or we'll get calls from people saying, can you help me get power of attorney over my grandmother? The answer is no, you can't. It doesn't work like that. Only the principal, the person who needs someone to do things for them, can execute that power of attorney. So if you are appointing somebody to do things for you, you are the only person that can set that up. Nobody can execute a power of attorney on your behalf. And so if you get to a point where you're unwilling or unable to sign a power of attorney, then there's no way for someone to get one over you. The person who needs to help you with things in that situation would have to seek guardianship, which again does require a court order declaring incompetency. So a power of attorney is something that you can decide to execute, but nobody can decide to execute it for you. So that was a financial power of attorney. Next, I'll talk about a couple of healthcare directives. First, the healthcare power of attorney. The healthcare power of attorney is a document that names someone to make your medical and healthcare decisions for you if you're no longer able to make those decisions, or even if you're just unable to communicate those decisions to your doctors. So just like the financial power of attorney, you're appointing an agent with the healthcare power of attorney. You're giving authority to someone to do things for you. The difference here is you're appointing somebody to make healthcare decisions for you. So one example of when this might come into play is if you are in a car accident and you're unconscious, and your healthcare agent could then decide to consent to surgery for you. They could consent to diagnostic tests like x-rays or CAT scans, whatever you need to happen. Basically, whatever you would consent to for yourself, they could consent to for you. So I just mentioned some examples of what they could consent to, basically diagnostic tests, surgery. They could get you admitted wherever you need to be admitted, like a nursing home, an emergency room, any kind of facility for treatment. And this authority in the healthcare power of attorney is meant to be very broad and cover whatever you would normally decide about your own healthcare. You can put limitations on this authority. It doesn't have to be broad. Most people want it to be broad so that it will cover whatever happens. But if there is something that you don't want your healthcare agent to decide for you, it is possible to put limitations in the document about what they can decide. So it goes into effect, the healthcare power of attorney, if and when you are no longer able to make your medical decisions for yourself, or you're no longer able to communicate your wishes. As long as you can make and communicate your own medical decisions, though, your doctor should always go to you and only you. And it only gets used if and when you're not able to do that. The last document I'm going to talk about is a living will. This is also a healthcare directive, and this goes kind of with your healthcare power of attorney. Sometimes the two documents are done as one, a combined document, or they can be done separately. But a living will is a document that tells your doctors if at the end of your life, if you do not want to be kept alive with extraordinary life prolonging measures. For example, your living will might say that you do not want to be put on a ventilator. So to put it crudely, what some people think of this as is the document that says when to pull the plug, when to unhook the machines toward the end of your life. If you, for example, are unconscious and not expected to regain consciousness again, or if you are about to die very soon, this tells doctors when you would want to have treatment withdrawn and not have any extraordinary means keep you alive. Now, some people actually want to be kept alive as long as possible, any way possible. If that is what you want, then you do not want a living will. This document is only for people who want to say when to withdraw treatment, when to unhook the machines, so to speak. So like the healthcare power of attorney appoints somebody else to make decisions for you. The living will does not appoint somebody else. It just expresses your own wishes for end of life care and when you would want treatment to be withdrawn. You can have both of these documents. Some people just have one or the other, but a lot of people choose to have both of them. Another type of advanced directive is a do not resuscitate order. This is sometimes confused with the living will, but it is different. For one thing, it's very specific. It's just about whether you want to be resuscitated. But also a critical difference here is this is a medical order, which your doctor has to issue. So attorneys do not prepare DNRs. We can prepare the healthcare power of attorney or the living will, but a DNR is something that you get from your doctor, not from an attorney. You can have this along with a healthcare power of attorney and or a living will. If you want all of these, it is possible to have all of these documents. So what is needed for these documents to be valid? They do have to be executed in a formal way. So with your will, for example, if you were to email your neighbor and say, I want you to get everything, there's nothing legally enforceable about that. Your neighbor is not entitled to anything after your death just because of that email. Similarly, if you, let's say your grandfather drives you around the farm and says, this will all be yours someday, that is not a valid will and doesn't entitle you to anything. So a lot of people do have things said in their families, even if it's said consistently over time, no matter how much the person means it, If it's just things that they say and they don't put it into a formal written will, it has no legal enforceability as a will. And so if you know that you want certain people to get your property, you do need to have your will executed properly. And as far as the signing, there are particular requirements. Your will and your healthcare directives do need to be signed by you, by two witnesses, and by a notary. The witnesses have to be neutral or disinterested, meaning that they shouldn't be beneficiaries named in your will. They shouldn't be immediate relatives who potentially have anything to gain when you pass away. They shouldn't be paid healthcare providers. They should be completely disinterested parties. And the power of attorney, the financial power of attorney, that is, also needs to be notarized, but that one does not need two witnesses. So those are the signing requirements. Now, people ask a lot about templates and just doing these documents on your own. Some people do that, and it is possible to do that. I can't recommend that. There's just a lot of ways that you can go wrong, and the way that you execute the documents, or even in the language that you use. Some templates do not have user-friendly language, and if you don't completely understand what you're signing, that could be a big mistake, since there's a lot at stake with all of these documents. And with a will in particular, you want to have language that can't be misconstrued. If you have anything ambiguous in your will that people could interpret different ways, then that creates a potential for someone to contest your will. So for those reasons, it's ideal to have an attorney prepare these documents for you, if at all possible, rather than trying to do it on your own. So that is my presentation, and I know that was very general, but if anybody has follow-up questions, I am here and happy to start answering questions.
Okay, so like you said, feel free to put your questions in the chat, whether you're the chat box on Zoom or the comment section on Facebook. You cannot unmute, so you will need to, I see some raised hands. You will need to type your questions in the chat box. First question that we have here. If someone has all bank account/retirement accounts set up with payable on death beneficiaries and does not own a home, then the will's distribution of property is only for items such as a car and the contents of the home. Is that correct? And do these items have to go through probate?
So, okay, I'm sure I completely understand the question, because there was a lot packed into that question.
Yeah.
Let me give it a shot here. So first of all, with bank accounts, if you have those set up payable on death to somebody, then your will is not going to change that. And even if you don't have a will, those accounts are going to go to who you have selected that they be payable on death to. You can do that through your bank. People do that sometimes with investment accounts or with life insurance policies. If you have beneficiaries selected through a policy or on an account, then that is covered, and your will doesn't change that. Now, if you're asking about avoiding probate and not needing your executor to open an estate file for you, that is a much bigger and kind of complicated question. Whether your executor needs to open an estate file for you and go through the probate process is going to depend on all of what you own at your death. And the big thing is often real property. It does make a difference if you own any buildings or land. If you do, then they are going to need to go through that probate process. But also, if you own a car that's titled in your name and not in anybody else's name, then they're probably going to have to open an estate file to have that titled to somebody else. If you have any accounts where you haven't set them up as payable on death, or you haven't selected beneficiaries, then that's another reason that they might have to go through that probate process. So basically, if anything needs to be formally titled in somebody else's name, they're probably going to have to do that. If that didn't answer your question, please let me know and I'll try again.
We'll see. New question. If a home is only deeded to one individual and that person's spouse dies, does that person's spouse have an interest in the house?
Okay.
I'm assuming the spouse is not on the deed.
Oh, if the spouse is not on the deed.
Mhm.
That is getting a little specific. There are different ways of deeding property, and generally during a marriage, when two people are on the deed together, we call that a tenancy by the entirety, and one house would inherit the other share. If the spouse is not on the deed, we would want to see exactly what the deed says. We would want to get a little more information about that. So I'm hesitant to try to answer that without more information.
No worries. Not seeing any other questions. Gonna give it just a moment here if you're typing. All right, as I am not seeing any other questions, I'm going to go ahead and say thank you all for joining us, with a special thank you to Jennifer for presenting for us. If you would like to review anything talked about today, we have posted the recording of today's event to our Facebook. It will be immediately available. You can access this with or without a Facebook account at www.facebook.com/legalaidnc. If you would like to register for one of our other Listen and Learn presentations, such as Medicaid eligibility, SNAP, Social Security disability, child custody, you can do so on our website at legalaidnc.org/clinics. I hope you guys have a great rest of your afternoon.